Give me a minute. Let me call you back, Stephanie.
Hi, it just started.
It's a pre-recorded webinar.
No, it's live.
Live?
Yeah, so it seems like it's okay.
Alright, no problem.
Hi, everyone. Thank you for joining our webinar. We will begin in about 5 minutes. Just want to remind you of some of our guidelines for our session today. If we can keep all our microphones muted and place your questions and comments in the chat throughout the session. Please raise your hand during the Q&A segment. And as I said, we will begin in about 5 minutes. Thank you, everyone. Hello again, everyone. I would just like to say welcome to our second session. 1 second, please. Sorry about that, everyone. everyone. Sorry about that delay. Our presenter is having some technical difficulties as right now there appears to be a blackout in New York. However, I would like to tell everyone welcome to the session. Thanks for making the time to join today. We really appreciate it and we hope that you get a lot from this session. Today, our presenter is Judith Bachman. Judith is the founder of the Bachman Law Firm. The Bachman Law Firm protects business clients and helps them grow while providing counsel to a range of businesses, including those with 5 employees or more, with revenues of more than 3 million. Sorry about that. Judith has been practicing law for more than 25 years. She's licensed in both New York and New Jersey. Judith also serves on boards of the Rockland County Women's Bar Association, the Rockland Business Association, the Rockland Economic Development Council, the New York State CPA Society, Rockland Chapter, and the Commercial Committee of the Westchester Women's Bar Association. Ladies and gentlemen, I would now like to present our presenter, Miss Judith Bachman. Judith? One second, ladies and gentlemen.
Hello?
Hi, Judith, are you with us now?
I am, and I'm actually trying to get on Zoom, but can you guys hear me?
Yes, we can hear you.
Okay, great. So again, I apologize for the jury-rigged technology, but we are experiencing a blackout here with the storm. I hope you guys are safe. But I want to get right to it. The issues that you guys have in mind and any questions that you have, I want you to feel free to interject. I'm going to go over sort of a general background as to what legal issues entrepreneurs should be thinking about, either when establishing or building their businesses. I know that there are a range of people in the listening audience who might have plans to launch a business but have not yet done so, and some that have already done so and have been in business for some time. I'm going to try to cover that broad spectrum, but again, if you have specific questions, let me know. We do have a set of PowerPoint slides that we can run through, although I'll be blind when we do it. And that should at least give you an overview, and then we can share the slides after the presentation so that everybody has them at hand. So I'm going to go to the first slide, which just touches on generally what I'm going to speak about, the heading of which is legal considerations for the entrepreneur. And I want you to think about the legal issues as covering 3 broad topics. One is intellectual property, which we'll talk about what that means in a second. The second is securing your relationships through various tools. And the last is thinking about and avoiding liability risks. If you can master each one of those 3 areas, you will be well on your way to running and building a successful business, and can do so for a very long time. So to start, I'm going to touch on intellectual property. And again, if anyone has any questions, please interrupt and let me know. There are 3 areas of intellectual property that I want to touch on. 1 is copyright, 2 is trademarks, and 3 are patents. And just an asterisk for you, I am obviously a U.S. lawyer based in New York and New Jersey. So what I'll be speaking about are either general concepts on intellectual property law or specifically, where appropriate, New York law. So keep that in mind as sort of a limitation. If there are other geographies that you are doing business in, it's those local geographies that are going to dictate what the law is that applies to you, as opposed to something in New York or the US. Everybody all right so far? I'm going to assume that's a yes, since nobody responded. So the first issue is copyrights. A copyright is actually a bundle of 5 different rights. It's not a single right. It is this bundle of rights which are designed to ensure that the owner of the copyright has the exclusive rights, to the exclusion of the rest of the world, that they alone can reap the monetary benefit from their works of authorship. So authorship has a specific meaning, but think of it as either art or specific creations, usually in writing or in pictures. So copyrights include 5 rights, and I know the slide is there. Those 5 rights are the right to reproduce, the right to distribute the work, the right to adapt or make a derivative work, and the right to perform and display. So 2 minutes on each of those. The right to reproduce a work means the right to copy it. The right to distribute the work means the right to sell it or publish it. The right to adapt or make a derivative work is the right to change the work from one form to another. The right to perform the work is literally to put on a performance of it, and the right to display the work is to show it in public. The easiest way to understand these 5 different rights is by example, and one really good recent example is the Broadway show Hamilton, right? So Hamilton, smash hit, great musical that really transmitted history in an entertaining and insightful way. When the pandemic hit, they took the play Hamilton, filmed it, made it into a movie, which was just shown on, I think, Disney Plus. Converting the play or the musical Hamilton from a performance in a play to a movie is an adaptation, and that is one of the 5 exclusive rights. So that should hopefully help you understand how you can utilize a copyright in 5 different ways. From a business owner standpoint, it's really important to understand not only what a copyright is, but how you get ownership of it. Typically what happens when you own a business is you have a staff of employees, and that staff is doing work and making creations on your behalf as the business owner. If somebody is creating something like writing a computer program, creating an app on behalf of you and your business, that is typically a work made for hire, and that is owned by the business owner and not the employee. If you are not the owner of the work, you can still get permission to use the work by paying for it, and that is typically done by virtue of a copyright license. So you can either essentially rent the right to use the work, or you can rent out the right to use the work by licensing it out. And there are lots and lots of ways to make lots and lots of money, assuming you create something that's valuable by licensing it out. So you retain the rights, the ownership, but you give other people temporary permission to use your work. So there is a huge stream of income to be gained by licensing intellectual property, and in particular copyrights. And the last piece I'll say on copyrights is that you acquire a copyright simply by creating the work. As soon as you create the work, either by virtue of an employee or yourself, you automatically gain the right to it. Under US law, you are not required to register a copyright, although it's a good idea to do so, because if you ever have to sue, having registered a copyright gives you extra rights, which we'll talk about later. And in the US, registering a copyright is as easy as filling out a one-page form and paying $60. So it's kind of a no-brainer to do. And I strongly recommend for those of you who are creating what you think are works that you want to make sure you have the copyrights in, registration is important. So I'm just going to pause and see if anyone has any questions. I know that there are some things in the chat. It looks like we do have the slides running, so feel free to watch the slides through and put into the chat any questions that you might have. So we're going to go on to the next slide, which is touching on trademarks. So this is the second type of intellectual property. I want you to think of...
I am seeing a question in the chat.
Sure.
What types of items can you and can you not copyright?
Sure. That's a great question, and it's actually a much more complicated answer than you might think. So the first thing that people confuse is what's covered under copyright, what's covered under trademark, and what's covered under a patent. So you cannot copyright an idea or an invention or a short phrase. So an idea or an invention is not subject to copyright. It might be subject to a patent, but it's not copyrightable. A short phrase also cannot be copyrighted. That, in turn, could be covered under a trademark, but it is not subject to a copyright. What you think of in terms of copyright are like a play or a novel or a work of art. Those are all things that are subject to copyright. I also see another question in there. Can you speak more on work for hire, employee, employer ownership of work? So to review, a work made for hire is in the employer-employee setting, where an employer tasks an employee with creating something. In an employer-employee setting, or an employer-independent contractor setting, you are paying for them to create the work, and therefore you, as the financer of the work, in most cases own the copyright as the financer of the work rather than the creator of the work. There are some tests that courts use, like an 8-factor test to determine if something's a work made for hire or not. We don't have the time or the scope to go into those 8 factors, but the best thing to take away from that sort of confusion about which is which is make sure that you have an agreement in writing between you and your employees and you and your independent contractors that say explicitly, you as the employer own the copyrights in any works that your employees or your independent contractors create as a work made for hire. So once you declare that by contract, you have some safety, and you would also put in a catch-all to say, and by the way, if this is not a work made for hire, then you, the person who did it on my behalf, you're going to assign me the copyright. So by contract, you can get some certainty where otherwise there may be some question as to whether or not it's a work made for hire. but the default definition of a work made for hire is employer-employee, and the work is owned by the employer. Another question, what about a blog or a video? Is that subject to copyright? The answer is yes. Both a blog and a video are subject to copyright. So again, think about artistic expressions, and they don't have to be Picasso. Any work of creative effort, like a blog or a video, assuming it's yours, it's original to you. It's not that you went on YouTube and copied somebody else's video. You created the video yourself. That is subject to copyright. Okay, I'm going to move on to trademark because I think we have some other things to cover and I want to make sure to cover them. I'm going to go a little bit faster, but feel free to keep the questions coming. So a trademark is, the easiest thing to do is think of it by example. If you're traveling in China, right, you've never been to China before, you have no idea what life in China is like, and across Tiananmen Square you see the yellow golden arches staring at you. You know instantly, no matter what else life in China is, you know that you have just come across a McDonald's, and you know exactly what the menu is going to be. You know exactly what the prices are going to be, even if they're in yen or whatever. And you know exactly what the food is going to taste like and the experience is going to be. The McDonald's Golden Arches are the classic trademark. A trademark is any design, device, logo, or slogan that identifies and distinguishes a product or service from one company to another. So it's the thing where people will look at it and they know it's McDonald's, not Burger King, not Wendy's, not any other brand. They know it's hamburgers by McDonald's. To get a trademark, at least in the US, all you have to do is actually be the first one to use the particular mark. You don't have to register it. You don't have to make any formal declaration. You don't have to put the little TM next to it. All you have to do is be the first one to use it. Even so, just like a copyright, there are some advantages to registering a trademark, and those advantages really are focused on if you ever have to sue, using a registered trademark gives you a lot more rights than if you're using a trademark that you have not registered. So we're going to go to the next slide. Again, put in your questions about either trademarks or intellectual property in general. I'm going to go quickly to patents. I am not a patent lawyer. There's a specific bar for patent lawyers, and they usually have a science background. That is definitely not me. I will just tell you conceptually that a patent covers an idea or an invention. The idea or invention to be eligible for a patent has to be new and not obvious. So you cannot, and it's very important, if you have an idea or an invention that you think you want to patent, you cannot go out and use it or sell it and then later patent it. It has to be new. So you have to patent first and use it second. And to obtain patent rights, at least in the US, you must register your patent. You do not get patent rights without registration, and it is a long and expensive process. So you want to think very carefully about whether trying for a patent is worth it or not for you. Just to loop back for a second, I see a question with regard to trademark. I assume it refers to McDonald's. The question is, suppose the M was a different color, right? So I said those golden arches, what does that mean? And the question is, what if they weren't golden? What if they were green? Does that mean that it's infringing on McDonald's trademark or not? although the golden arches, right, the idea that they're golden is sort of classically part of the McDonald's trademark, I would say the shape and the letter itself and the texture are probably enough to get it to be part of the McDonald's trademark. And in considering trademarks, courts look not only to see whether it's identical, right? If I put up a competing hamburger store and I use a green M rather than a golden M, would a court say that I infringe the McDonald's trademark? The test that a court uses is am I putting up a logo that others might confuse with a trademark? So if I can prove, and I'm McDonald's, that somebody going by a green M would mistakenly think that it was McDonald's, that they just changed the color, then I've probably infringed their trademark. So the color in a McDonald's trademark is probably not the hallmark of whether or not it's owned by McDonald's or not. Okay, gonna go on and speed things up a little bit. Moving on to relationship protection. In particular, I'm going to talk about first corporate structure. So if you take nothing else away from this conversation, I urge you to spend some time on a task that many business owners skip or don't give very much thought to, and they often later regret it. And that task is with regard to forming the right kind of company. You really want to form the right kind of company for a lot of reasons. One of them, and the most important, is to get liability protection. We're going to talk about the risks that business owners face. If you form the right kind of company and maintain it in the right way, your company itself could be sued, but your personal assets, like your house, your car, your dog, your bank account, those should be insulated from liability. So forming a corporation or another kind of entity is really important. And the second reason why you need to spend a lot of time thinking about this issue is if you have big dreams, like you want to get investors or you eventually want to sell your business, forming the right kind of company will enable you to get investors when your business gets more value or sell. If you fail to do that, you will not have liability protection and you will not be able to get investors or sell. So the 4 different types of entities to think about are partnerships, corporations, limited liability companies, and joint ventures. To get liability protection, you need to have either a corporation or, in the US, it's called a limited liability company. The reason only those 2 entities give you liability protection and the ability to get investors or sell is because under US law, corporations and limited liability companies are considered people, separate entities apart from the owners themselves. And because they're separate entities, if there is a lawsuit, it's the assets of that separate entity and not the individual owners that are at risk. And also, if you have a corporation or an LLC, you have essentially stock that you can sell either to investors or to buyers. So that of the 4 types that I've listed for you, you really want to spend careful time thinking about forming either a corporation or a limited liability company. Otherwise, if you do not take the formal steps to do that, you are going to be deemed either a sole proprietor, meaning just an individual business owner, or if you have others you're working with, that would be a partnership. And from a legal standpoint in the US, solo entrepreneurs or partners or joint venturers are individually liable if their businesses get sued and they have nothing to sell to an investor or in a buyout. So forming a corporation or an LLC is really the way to go. People resist because it takes a little bit of time and a little bit of money, but at the end of the day, it's well worth it. In the US or in New York in particular, forming a corporation can be done literally in 2 hours, and it costs under $1,000. In New York, forming a limited liability company also can be done in the same day. That costs a little bit more money because there's an extra step, but it's about, my estimate would be about $1,500. And in the long run, between the liability protection and the investment possibility, it's well worth it to spend that money. All right, we're going to go on to the next slide, if there are no questions there. And the next slide talks about contracts. So contracts is the formalization of an agreement between parties. It typically is done to allow you to legally enforce a promise on either side. The promises must be in exchange of value. So it can't be that I say, hey, I have an old car that I'm not using anymore. I think I'll give you my car. You haven't given me anything in return if I'm just giving it to you as a gift. So therefore, if I change my mind and don't actually gift you my car, you can't sue me and force me to give you my car. A contract, at least in the US, is enforceable whether it's in writing or verbal, but it is 1,000 times easier to enforce a written contract than an oral contract because you have something to show the court. If it's an oral contract, all you have is just one person's word against the other. So it seems basic, but again, another important takeaway is that whatever you agree to with your customers, your counterparts, your investors, your employees, it should all be in writing. There's no magic formula to written contracts. You can make a contract by email. You can make it by text message. It just has to be or should be in writing so it's clear and provable what the terms are. All right, I don't see anything in the chat so far with regard to those things. So I'm going to move on to non-disclosure agreements, which is the next slide. So non-disclosure agreements are really important when you're building a business. A non-disclosure agreement is a type of contract. It is designed to ensure that you have confidentiality and the confidence that you can share things that you would otherwise not want to become public, and you know that the other side is bound to keep your secrets secret. It is essential to have a non-disclosure agreement when you're looking for investors, you're looking to sell your business, when you're hiring consultants, when you have professionals assisting you. Those people are going to have access to really sensitive information that could hurt you or be a detriment to your business prospects. So it's essential that you have a non-disclosure agreement in place. Again, the subject matter of the non-disclosure agreement is information that is not public, that you have treated as confidential within your own business, and that is at the heart of you being able to manage and maintain and grow your business. So I'm not sure how closely you guys have been following the lovely political situation that we have in the US, but President Trump is well known for having required people in his circle to sign non-disclosure agreements. And his niece, Mary Trump, recently published a book, which was sort of a tell-all with regard to the family history. And President Trump tried to get her to be prevented from publishing that book because she had signed a non-disclosure agreement as part of a settlement in prior litigation. So the court balanced the provisions of the non-disclosure agreement with the pressing public interest and decided she could publish it. But that's an example of a non-disclosure agreement trying to keep non-public information secret. Often in a non-disclosure agreement, you have what are called liquidated damages, which I'll talk about in a few minutes, but basically it's naming a price if somebody breaches the agreement. So if I have a non-disclosure agreement with you and you go out and tell my secrets, if I sue you and win, the non-disclosure agreement might say you have to pay me $1 million. Even though I can't prove that the secret you disclosed cost me $1 million, by the language of our non-disclosure agreement, I might have already named that price and you agreed to it. Again, I'm looking for questions in the chat, so just let me know if you have any. But if not, I'm going to move on to liability risk.
There is one question that we have. And
Sure.
the question is, when you do computer programming, you have source codes. What is the best way to protect these codes?
Right, and that's a really critical question. If you're in the programming world, your source code is the keystone to your whole business, right? And if your source code gets out, that's a problem. So there are multiple ways to protect source code. It depends. So some of the tools we talked about already. One is you can actually copyright your source code. Two is you want to cover it under a non-disclosure agreement with the people who are working for you or with you. And three is if you have customers, you want to put in your terms and conditions that they will never have access to the source code and the source code is yours. And fourth, depending on what the source code does, you might actually be able to patent it as well. So you have two intellectual property tools, copyright and patents. You have two contract tools, a non-disclosure agreement and the terms and conditions with your customers. Okay, going to go on to the last slide, which is a subject that will keep everybody up at night, but it's good to tackle it so that you know what might be at risk, and that is the subject of liability risks. So you need to understand what your risks are to avoid them. So types of liability, depending on what type of business you're in, will determine what type of liability you could be exposed to. So if you make and sell products in the U.S., you are subject to product liability. Product liability, think of it as, you're a toy manufacturer and a child goes out, uses your toy, and they hurt their foot. You could be sued and held liable for their injuries, for the child's injuries, whether or not you knowingly or carelessly did anything or not. Simply by virtue of manufacturing and selling the product, you are strictly liable for injuries caused by that product. So the level of danger in being a manufacturer is very high, and anybody who manufactures products, it's critical that they have adequate insurance in place because of the strict liability that they will face if somebody gets injured. The other type of liability is negligence. Negligence is implicated if you've taken an act carelessly. You haven't done what a reasonable person would do, and in turn, somebody gets hurt. You can also have insurance essentially against your own negligence. I, again, urge you as another key takeaway to this conversation, you should never launch a business or maintain a business without a careful conversation with an insurance broker who will walk you through what coverages you need and what coverages will cost. Do not be penny wise and pound foolish. Affording insurance, spending the money on insurance is as important a protective measure as you can possibly take. It is a cost of doing business, and it is an essential cost of doing business. Spend the money for it. The other types of liability we can touch on are breach of contract, right? So if you've signed a contract to provide 500 widgets and you don't provide those 500 widgets, you can be sued and required to actually produce the 500 widgets or pay damages for what the other party lost when you failed to provide the 500 widgets. And the other type of liability to talk about today is infringement of intellectual property rights. So if you go out, and this often happens when people try to market for their business, they go out on the internet and they're looking for a meme or a video clip or something to put into their own postings. And for some reason, people mistakenly think that if it's out there on the internet, oh, I can copy it and use it for my own purposes. You cannot. Stuff posted on the internet is copyrighted, just as if it were a picture hanging in a museum or an article published in a magazine. Copying things off the internet is an infringement of intellectual property rights, and there are lawyers who spend all day, every day, sending letters out, demanding money and cease and desist letters to people who have copied things off the internet. So again, another easy takeaway is please don't copy things off the internet. Just create your own stuff, or if you really want to use something off the internet, you got to get permission to do so. And the final piece to share with you is types of remedies. So if you are found liable, what is it that you might have to pay or do? So there are a couple of categories, 4 categories that you need to know about. The first category is called compensatory damages, where basically you have to write a check to pay for anything that the other side lost. What were they actually, what were they supposed to get? And you have to write a check to cover what they lost. The second type of damages are consequential damages, which are not only what they lose in the transaction, but what else could they have had you delivered what you were supposed to? What else could that plaintiff have profited by using what you were supposed to provide? So not only did they lose the $500 that you were supposed to pay them, but maybe they would take that $500, invest in new machinery, and that machinery would have generated another $10,000 in profits for them. You would have to pay the $500 plus the consequential damages of their $10,000. The third type of remedy are called liquidated damages, and I use this example in the non-disclosure agreement conversation. Liquidated damages are where you name a price. So if I disclose something that I shouldn't have under a non-disclosure agreement, I might have agreed in advance to pay liquidated damages of $1 million. And the last type of damages are called statutory damages. And the reason they're called statutory damages is they're set by statute or by law. So U.S. copyright law, for instance, sets damages for infringements of copyrights. So if I sue you for copyright infringement, I can choose to get paid by you the amount set by statute, which may be well in excess of the amounts I actually lost by virtue of the copyright infringement. So statutory damages give me access to a whole lot more money sometimes than what I would otherwise get in a regular lawsuit. So those are the 4 types of remedies: compensatory damages, consequential damages, liquidated damages, and statutory damages. So yeah, somebody put in the chat the display of the types of remedies. There is no slide for it. I was just listing it for you. I'll go over it one more time. 4 types of remedies. The first is compensatory. That is, you get what you lost. The second are consequential damages, which are not only what you actually out of pocket lost, but your future losses as well. The third is liquidated damages, which are a named price by contract. And the last are statutory damages, which are a set amount of damages which are in place because of a particular law or statute. So those are the 4 types of remedies. So those are all the slides I have. We wanted to leave a little chance for any questions that anybody else might have. So I'm happy to.
Question in the chat, and the question is from Michelle R, and she's asking, what if a product that you purchase and resell hurts a customer? What kind of liability will your business face?
Wait, so can you repeat the question? I didn't hear it.
What if a product that you purchase and resell hurts a customer? What kind of liability will your business face?
Yeah, so unfortunately, you as the middleman are equally responsible for product liability. So it's in the stream of commerce, that's sort of the phrase, right? Somebody manufactures a toy. You're a distributor. You buy that toy. You buy a pallet of 10,000 of those toys, and then you resell that toy on eBay, and somebody buys it and gets hurt. You as the seller of those toys, even though you didn't manufacture it, you are equally as liable for product liability. So as between you and the injured person, you are responsible. You might, depending on what your agreement is with the manufacturer, be able in turn to sue the manufacturer. In part, again, you want to think about insurance, even if you're the middle person, if you're the distributor, and you want to think about your contractual relationship between you and the manufacturer and make sure it's clear that you can turn around and sue them and that they ultimately will be responsible.
Okay, another question coming from Clifford. What if 2 independent companies are working to achieve the same functionality? Once the functionality is achieved, is anyone in breach?
So I assume you're saying two companies are working on the same project. They're not related to each other, but it's sort of a race to find or to develop the source code that will achieve a particular outcome. As long as they
clarified by saying he's speaking about source code.
Right. So if they're completely independent, it's kind of like, right, the invention of the light bulb. I think Thomas Edison was working on it in the US and somebody was working on it in Europe. They invented it about the same time. They each are the inventors or creators, and so long as they didn't steal trade secrets or infringe or do something to either interfere with or take the intellectual property of the other. If it's just a race to create something, they are each the creators of their own stuff, and there's no liability. Just like, you know, there are lots of manufacturers right now racing to create a vaccine for the coronavirus. If Pfizer creates one and Merck creates one, okay, they've each created one and they can go about their business and see who can sell more of it. So they are independent from each other and not responsible to each other.
Okay. We have a question here from Scholastic Oasis Caribbean. If you use an open software to build a software program, you build on top of it your own source codes. Does this have any legal implications in terms of copyright or patents or anything else?
Right, so by open source code, I assume you mean somebody's put out into the world their copyrighted work and said, you know what, we're not preventing anyone from building on top of this. You world, go out and develop more code on top of this, which in copyright terms would be a derivative work, meaning you're creating more code on top of the original code. You, as the author of the additional code, could have a copyright or patent in that additional code you created, but you can never cover the original open source code. So let's say, for a really simple example, you end up with a program with 10 lines of code. The first 2 were open source created by somebody else. You added 8 more lines of code. You could get a copyright or, if appropriate, a patent on those new 8 lines of code. You cannot get a copyright or patent on the original 2 lines of code because they're not yours.
See another question here. What are the liabilities of non-shareholder board of director members?
Boy, I have to say these are great questions. So a non-shareholder director could potentially be liable to the shareholders if they act in a way that is either in their own self-interest over and above or as opposed to the corporation's interests, or they act grossly unreasonably. So for instance, if the board of directors is considering giving a $10 million contract to a trucking company to deliver their products, and it turns out the director owns that trucking company, the director would be liable essentially for what's called self-dealing by voting and approving on that trucking contract when it's really to her benefit rather than the corporation's benefit. So that's an example where a director would be potentially liable for hurting the corporation and putting their interests above, their personal interests above that of the corporation. Directors are generally protected so long as they act in the corporation's interest primarily and they act reasonably. They are protected by what's called the business judgment rule. So long as they're acting in a reasonable way, they will be insulated. But if they act unreasonably or in their own self-interest, they will be liable.
Okay, I see here one more question. How does one go about copywriting product development if similar products are currently on the market?
So as long as the product you're developing is unique to you, even if there are, 1,000 different television models or 1,000 different YouTube videos on a particular subject, so long as you create it, it's new to you, you have the right to protect it. So even though there are thousands and thousands of other YouTube videos out there on the subject of, how to tap dance, so long as you uniquely create your own how-to video on how to tap dance, you can get a copyright in it because it's unique to you.
Okay,
I
I'm
think
not
that's
seeing
it.
any more questions in the chat. If anyone has any more questions, okay. Okay, recognizing the value of a lean startup, do you have any recommendations for small businesses to get these basic legal things in place without hiring a law firm on retainer? Suggestions for possible templates, if any.
So I have a couple of recommendations. Again, you have to always balance cost and benefit. So many entrepreneurs obviously have a limited budget in their early days, and I appreciate that. There are some tasks that do not require a law firm to do. So for instance, to form a corporation or a limited liability company, you can go directly to the particular state, like New York. You can go to the Secretary of State website. You can fill out the forms and pay the filing fee yourself. That will save you the cost of a lawyer, and it will save you the cost of even a corporate agent. Additionally, there are websites out there that purportedly give you lower cost legal services, like one is LegalZoom. I would use those services cautiously because they sort of give the mirage of giving you legal advice when they don't really. All they're giving you are forms. But for simple tasks like forming a corporation, they're good starting places. I would rather you use, if it's a choice between not taking steps to protect yourself legally or using one of those services, I would say use one of those services. But those services have very limited value, and at some point you're going to need to hire a lawyer to get the real work done. But at the very beginning, you can go, so the answer is go directly to the government entities yourself and their websites. Use lower cost providers like LegalZoom. And in the US, we also have bar associations that will sometimes do work for free or will provide low cost attorneys for those in need. So those are three ways you can do it without having to hire a law firm.
Okay, I'm not seeing any more questions, and I do know that we are just about out of time. I just wanted to say thank you so much, Judith, for coming on today and making your presentation. I do know that, you know, you're facing a blackout right now, but we pivoted and we were able to make this happen. I think our participants are very grateful for the information that you have been able to provide to them and the questions that you have been able to answer. I do see where we have our benefactor, Mrs. Sabrina Hosang Jordan, on the call. And I would just like to say thank you, Sabrina, for introducing me to Judith so that we can have this wonderful presentation today. I greatly appreciate it.
Oh, yes, and thank you, Ashley, and thanks to your team for organizing this. Judy has helped our company, Caribbean Food Delights and Royal Caribbean Bakery, and protected us from problems that could arise in the future. So she did a great job, and you guys all had great questions. And I just want to say that continue to be safe and study and learn as much as you can so you can be successful in your future career. And the sun is shining, so hopefully New York is back online.
Thank you so much. And as you all may see on your screen now, where our third webinar series episode will be on strategic marketing. Everyone wants to know how to pivot during this COVID situation, how best we can market given our circumstances, and what we should do now. We are definitely facing a whole new world, and we need to know how to go forward. So it is Tuesday, August 11th, same time. And you will see the registration link on the screen as well as the barcode. Feel free to scan to register now, and the information will be posted on our socials. And I just wanted to tell everybody, thank you for joining. Remember guys, note takers are money makers. So when we hop onto these calls, let's just ensure that we're taking notes as best as possible and getting the information that we need. Thank you everyone, and enjoy the rest of your day.